Hello friends, welcome to Premier Upsc Ias. So continuing with the polity lectures, today we are going to cover the panchayats, the municipalities and the cooperative societies. Evolution of local government. The subject of local government is mentioned in the state list under the 7th schedule of the constitution. Balwant Rai Mehta Committee 1957. The committee submitted its report in 1957 and recommended the establishment of scheme of democratic decentralization which ultimately came to be known as Panchayati Raj. The committee recommended the establishment of a three-tier Panchayati Raj system such as Gram Panchayat at the village level, Panchayat Samiti at the block level and Jila Parishad at the district level. These recommendations of the committee were accepted by the National Development Council in January 1958. The council did not insist on a single rigid pattern and left it to the states to evolve their own patterns suitable to local conditions. But the basic principles and broad fundamentals should be identical throughout the country. Rajasthan was the first state to establish Panchayati Raj in 1959 in Nagaur district. Rajasthan was followed by Andhra Pradesh, which also adopted the system in the same year. Thereafter, most of the states adopted the system. Ashok Mehta Committee 1977. In December 1977, the Janata government appointed a committee on Panchayati Raj institutions under the chairmanship of Ashok Mehta. It submitted its report in August 1978 and recommended to revive and strengthen the declining Panchayati Raj system in the country. Due to the collapse of the Janata government, no action could be taken on the recommendations at the central level. However, three states of Karnataka, West Bengal, and Andhra Pradesh took steps to revitalize the Panchayati Raj, keeping in view some of the recommendations of the committee. G.V.K. Rao Committee, 1985. The committee to review the existing administrative arrangements for rural development and poverty alleviation programs under the chairmanship of G.V.K. Rao was appointed by the Planning Commission in 1985. The committee came to conclusion that the developmental process was gradually bureaucratized and diverged from the Panchayati Raj. This phenomena of bureaucratization of development administration as against the democratization weakened the Panchayati Raj institutions, resulting in what is aptly called as grass without roots. Hence, the committee made the recommendations to strengthen and revitalize the Panchayati Raj system again. Thus, the committee, in its scheme of decentralized system of field administration, assigned a leading role to the Panchayati Raj in local planning and development. Finally, the G.V.K. Rao Committee recommended reduction in the developmental role of the district collector and assigned a major role to the Panchayati Raj in the development administration. L.M. Singhvi Committee 1986. In 1986, Rajiv Gandhi government appointed a committee to prepare a concept paper on revitalization of Panchayati Raj institutions for democracy and development under the chairmanship of L.M. Singhvi. It recommended that the Panchayati Raj institutions should be constitutionally recognized, protected, and preserved. For this purpose, a new chapter should be added in the Constitution of India. Tangon Committee 1988. In 1988, a subcommittee of the Consultative Committee of Parliament was constituted under the chairmanship of P. K. Tangon. It was made to examine the political and administrative structure in the district for the purpose of district planning. This committee suggested for the strengthening of the Panchayati Raj system. Gadgil Committee 1988. The Committee on Policy and Programs was constituted in 1988 by the Congress Party under the chairmanship of V. N. Gadgil. This committee was asked to consider the question of how best Panchayati Raj institutions could be made effective. The recommendations of the Gadgil Committee became the basis for drafting an amendment bill aimed at conferring the constitutional status and protection to the Panchayati Raj institutions. In this context, the committee made the following recommendations. 1. A constitutional status should be bestowed on the Panchayati Raj institutions, a three-tiered system of Panchayati Raj with panchayats at the village, block, and district levels. The term of the Panchayati Raj institutions should be fixed at 5 years. The members of the panchayats at all the three levels should be directly elected. Reservation for SCs, STs, and women. The Panchayati Raj bodies should have the responsibility of preparation and implementation of plans for socio-economic development. For this purpose, a list of subjects should be specified in the constitution. The Panchayat Raj bodies should be empowered to levy, collect, and appropriate taxes and duties. Establishment of a state finance commission for the allocation of finances to the panchayats. Establishment of a state election commission for the conduction of elections to the panchayats. Constitutional Amendment Act of 1992, 73rd Amendment Act. It transfers the representative democracy into participatory democracy. The Act gives a constitutional status to the Panchayati Raj institutions. It has brought them under the purview of the justiciable part of the Constitution. In other words, the state governments are under constitutional obligation to adopt the new Panchayati Raj system in accordance with the provisions of the Act. Consequently, neither the formation of panchayats nor the holding of elections at regular intervals depend on the will of the state government anymore. The Act has given a practical shape to Article 40 of the DPSP part of the Constitution, which says that the state shall take steps to organize village panchayats and endow them with such powers and authority as may be necessary to enable them to function as the units of self-government. This Act has added a new Part 9 to the Constitution of India. This part is entitled as the Panchayats and consists of provisions from Articles 243 to 243O. The article has also added the Act has also added a new 11th schedule that deals with Article 243G. The Act also defined the compulsory and voluntary provisions, such as compulsory provisions 1. Organization of Gram Sabha, 2. Establishment of panchayats at the village, intermediate, and district levels, 3. Direct elections to all seats, 4. Indirect elections to the post of chairperson of panchayats, 5. 21 years to be the minimum age for contesting elections to panchayats, 6. Reservation of seats, 7. Reservation of one-third seats for women, 8. Fixing tenure of 5 years for panchayats at all levels, and holding fresh elections within 6 months in the event of supersession of any panchayat. 9. Establishment of a state election commission for conducting elections to the panchayats. 10. Constitution of a state finance commission after every 5 years to review the financial position of the panchayats. Voluntary provisions giving representation to members of parliament, both the houses and the state legislature, both the houses in the panchayats at different levels falling within their constituencies, providing reservation of seats, both members and chairpersons, for backward classes in panchayats at any level, granting powers and authority to the panchayats to enable them to function as institutions of self-government, in brief, making them autonomous bodies. Devolution of powers and responsibilities upon panchayats to prepare plans for economic development and social justice, and to perform some or all actions of the functions listed in the 11th schedule of the Constitution, granting financial powers to the panchayats, that is, authorizing them to levy, collect, and appropriate taxes, duties, tolls, and fees. Part 9. The Panchayats. Article 243 to 243D. Article 243 Definitions District Gram Sabha Population Panchayat 243A Gram Sabha 243B Constitution of Panchayats 243C Composition of Panchayats 243D Reservation of Seats 243E Duration of Panchayats and 243F Disqualifications for Memberships 243G Powers, Authority and Responsibilities of Panchayats 243H Powers to impose taxes by and funds of the panchayats. 243I Constitution of Finance Commission to review the financial position. 243J Audit of accounts of panchayats. 243K Elections to the panchayats, and 243L Application to union territories. 243M Part not to apply to certain areas. 243N Continuance of existing laws and panchayats. 243O Bar to interference by courts in electoral matters. Article 243A A Gram Sabha as the foundation. It's a body consisting of persons registered in electoral rolls of a village. It is a village assembly consisting of all the registered voters of that area in the panchayat. It may exercise such powers and perform such functions at the village level as the legislature of a state determines. Constitution of Panchayats. Article 243b. It provides for a three-tier system of Panchayati Raj in every state, that is, Panchayats at the village, intermediate, and district levels. Thus, it brings about uniformity in the structure of Panchayati Raj throughout the country. However, a state having a population not exceeding 20 lakh may not consider panchayats at the intermediate level. Composition of the panchayat in a state having the population above 20 lakh. 1. Gram panchayats at the village level, panchayat samiti at block or intermediate level, and Jilla Parishad at the district level. State Finance Commission. Article 243I. The governor of a state shall, after every 5 years, constitute a finance commission to review the financial position of the panchayats. It shall make the following recommendations to the governor: the principles that should govern the distribution between the state and the panchayats of the net proceeds of the taxes, duties, tolls, and fees levied by the state. B. The determination of taxes, duties, tolls, and fees. 3. The grants in aid to the panchayats. 2. The measures needed to improve the financial position of the panchayats. 3. Any other matter referred to it by the governor in the interest of sound finance of the panchayats. States the state legislature may provide for the composition of the commission, the required qualifications of its members, and the manner of their selection. The governor shall place the recommendations of the commission along with the action taken report before the state legislature. The Central Finance Commission shall also suggest the measures needed to augment the consolidated fund of a state to supplement the resources of the panchayats in the states. Urban local government. The term urban local government in India signifies the governance of an urban area by the people through their elected representatives. The jurisdiction of an urban local government is limited to a specific urban area, which is demarcated for this purpose by the state government. The system of urban government was constitutionalized through the 74th Constitutional Amendment Act of 1992. At the central level, the subject of urban local government is dealt with the following three ministers: Ministry of Urban Development and Poverty Alleviation, Ministry of Defense in the case of cantonment boards, and Ministry of Home Affairs in the case of union territories. There are the following eight types of urban local governments: 1. Municipal corporation, 2. Municipality, 3. Notified area committee, 4. Town area committee, 5. Cantonment board, 6. Township, 7. Port trust, and 8. Special purpose agency. Urban local bodies before 1947. The institutions of the urban local government originated and developed in modern India during the period of British rule, such as 1687 to 88, first municipal corporation in India was set up at Madras. 1726, municipal corporations were set up in Bombay and Calcutta. 1870, Lord Mayo's resolution on financial decentralization visualized the development of local self-government institutions. 1882, Lord Ripon's resolution has been hailed as the Magna Carta of local self-government. He is called as the father of local self-government in India. 1907, the Royal Commission on Decentralization was appointed and it submitted its report in 1909. 1919, under the diarchial scheme introduced in provinces by the Government of India Act 1919, local self-government became a transferred subject under the charge of a responsible Indian minister. Year 1924, the Cantonments Act was passed by the central legislature. 1935, under the Provincial Autonomy Scheme introduced by the Government of India Act of 1935, local self-government was declared as a provincial subject. Constitutional Amendment Act 74th. The Act gave constitutional status to the municipalities. It has brought them under the purview of justiciable part of the Constitution. In other words, state governments are under constitutional obligation to adopt the new system of municipalities in accordance with the provisions of the Act. This Act has declared a new part 9A to the Constitution of India. This part is entitled as the municipalities and consists of provisions from Article 243P to 243ZG. In addition, the Act also has added a new 12th schedule to the Constitution that deals with Article 243W. Constitutional Amendment Act of 2011, 97th one. The cooperative societies. The 97th Constitutional Amendment Act of 2011 gave a constitutional status and protection to cooperative societies. In this context, it made the following three changes in the Constitution. 1. It made the right to form cooperative societies a fundamental right. In Part 3 of the Constitution, in Article 9, the words cooperative societies were inserted. It included a new directive principle of state policy on promotion of cooperative societies. In Part 4 of the Constitution, a new Article 43B was inserted which says the state shall endeavor to promote voluntary formation, autonomous functioning, democratic control, and professional management of the cooperative societies. It included a new directive principle of state policy on promotion of cooperative societies. In Part 4 of the Constitution, a new Article 43B was inserted which says the state shall endeavor to promote voluntary formation, autonomous functioning, democratic control, and professional management of cooperative societies. It added a new Part 9B in the Constitution which is entitled The Cooperative Societies. It enshrined Articles 243ZH to 243ZT. The cooperative societies is a subject enumerated in entry 32 of the state list of the 7th schedule of the Constitution. Part 9B, the cooperative societies, Article 243ZH to 243ZT. Article 243ZH. Definitions, board, registrar, office bearer, etc. Then I, incorporation of cooperative societies. J, number and term of members of board and its office bearers. K, election of members of board. L, supersession and suspension of board and interim management. M, audit of accounts of cooperative societies. N, convening of general body meetings. O, right of a member to get information. P, returns. Q, offences and penalties. R, application to multi-state cooperative societies. Z, S, application to union territories. T, continuance of existing laws. Definition: cooperative society means a society registered or deemed to be registered under any law relating to cooperative societies for the time being in force in any state. Board means the board of directors or the governing body of a cooperative society, by whatever name called, to which the direction and control of the management of the affairs of a society is entrusted to. Office bearer means a president, vice president, chairperson, vice chairperson, secretary, or treasurer of a cooperative society and includes any other person to be elected by the board of any cooperative society. Incorporation of cooperative societies. The state legislature may make provisions for the incorporation, regulation, and winding up of cooperative societies based on the principles of voluntary formation, democratic member control, member economic participation, and autonomous functioning. Number and term of members of board and its office bearers. The board shall consist of such number of directors as may be provided by the state legislature, but the maximum number of directors of a cooperative society shall not exceed 21. The state legislature shall provide for the reservation of one seat for the scheduled caste or the scheduled tribes and two seats for women on the board of every cooperative society having members from such a category of persons. Emergency provisions. Article 352 to 360. 352 Article Proclamation of Emergency. Article 353 Effect of the Proclamation of Emergency. 354 Application of provisions relating to distribution of revenues while a proclamation of emergency is in operation. 355 Duty of the Union to protect states against external aggression and internal disturbance. 356 Provisions in case of failure of constitutional machinery in states. 357 Exercise of legislative powers under proclamation issued under Article 356. 358 Suspension of provisions of Article 19 during emergencies. 359 Suspension of the enforcement of the rights conferred by Part 3 during emergencies. 360. Provisions as to financial emergency. An unique feature of Indian Constitution. The rationality behind the incorporation of emergency provisions in the Constitution is to safeguard the sovereignty, unity, integrity, and security of the country, the democratic political system, and the Constitution. These provisions enable the central government to meet any abnormal situation effectively. During an emergency, the central government becomes all powerful and the states go in the total control of the center. It converts the federal structure into a unitary one without a formal amendment of the constitution. This kind of transformation of the political system from federal during normal times to unitary during emergency is a unique feature of the Indian constitution. Center state relation during normal times, federal structure, and center state relation during the emergency times, unitary structure. Types of emergencies. Article 352, War, External Aggression, Armed Rebellion, Proclamation of Emergency, National Emergency. Article 356. Article 356, the failure of the constitutional machinery in the state emergency or president's rule. Article 360, threat to the financial stability or credit of India, financial emergency. Hello, friends. Continuing with the emergency topic of the politics, Article 352, War, External Aggression, Armed Rebellion, Proclamation of Emergency, National Emergency. Article 356, the failure of the constitutional machinery in the state, state emergency or president's rule. Article 360, threat to the financial stability or credit of India, financial emergency. Effects of emergency on central-state relations, Article 353 and 354, on the life of Lok Sabha and State Assembly, Article 83 and 172, on fundamental rights, Article 358 and 350. National emergency, proclamation of emergency, Article 352. Grounds of declaration. Under Article 352, the President can declare a national emergency when the security of India or a part of it is threatened by the following: war or external aggression or armed rebellion. Moreover, the President can declare a national emergency even before the actual occurrence of war or external aggression or armed rebellion if he is satisfied that there is an imminent danger. When a national emergency is declared on the ground of war or external aggression, it is known as external emergency. When, on the other hand, when it is declared on the ground of armed rebellion, it is known as internal emergency. A proclamation of national emergency may be applicable to the entire country or only a part of it. The President, however, can proclaim a national emergency only after receiving a written recommendation from the Cabinet. This means that the emergency can be declared only on the concurrence of the cabinet and not merely on the advice of the Prime Minister. The 44th Amendment Act of 1978 introduced this safeguard to eliminate any possibility of the Prime Minister alone taking a decision in this regard. Further, in the Minerva Mills case 1980, the Supreme Court held that the proclamation of a national emergency can be challenged in a court on the ground of malafide or that the declaration was based on wholly extraneous and irrelevant facts or is absurd or perverse. Parliamentary approval and duration. Proclamation of emergency must be approved by both the houses of parliament. Within 1 month from the date of its issue. However, if the proclamation of emergency is issued at a time when the Lok Sabha has been dissolved or the dissolution of the Lok Sabha takes place during the period of 1 month without approving the proclamation, then the proclamation survives until 30 days from the first sitting of the Lok Sabha after its reconstitution, provided the Rajya Sabha has in the meantime approved it. If approved by both the houses of parliament, the emergency continues for 6 months and it can be extended to an indefinite period with an approval of the parliament for every 6 months. Every resolution approving the proclamation of emergency or its continuance must be passed by either house of parliament by a special majority, that is, a majority of the total membership of that house and a majority of not less than two-thirds of the members of that house present and voting. Revocation of proclamation. A proclamation of emergency may be revoked by the President at any time by a subsequent proclamation. Such a proclamation does not require the parliamentary approval. Further, the President must revoke a proclamation if the Lok Sabha passes a resolution disapproving its continuation. The 44th Amendment Act of 1978 also provided that where one-tenth of the total number of the members of the Lok Sabha give a written notice to the Speaker or to the President if the House is not in session, a special sitting of the House should be held within 14 days for the purpose of considering a resolution disapproving the continuation of the proclamation. Resolution of disapproval versus resolution approving the continuance. Resolution of disapproval versus resolution approving the continuation of a proclamation. The resolution of disapproval passed by the Lok Sabha only, adopted by a simple majority only, whereas a resolution approving the continuation of proclamation passed by both the houses of parliament, adopted by a special majority. Effects on the center-state relations. Article 353. While a proclamation of emergency is in force, the normal relations of the center-state undergoes a basic change in the following manner. change in executive relations, change in legislative relations, and change in financial relations. Article 354. 1. Executive during a national emergency. The executive power of the center extends to directing any state regarding the manner in which its executive power is to be exercised. In normal times, the center can give executive directions to a state only on certain specified matters. However, during a national emergency, the center becomes entitled to give executive directions to a state on any matter. Thus, the state governments are brought under the complete control of the center, though they are not suspended. Legislative during a national emergency. The parliament becomes empowered to make laws on any subject mentioned in the state list. Although the legislative power of a state legislature is not suspended, it becomes subject to the overriding power of the parliament. Thus, the normal distribution of the legislative powers between the center and state is suspended, though the state legislatures are not suspended. In brief, constitution becomes unitary rather than federal. The laws made by Parliament on the state subjects during a national emergency become inoperative 6 months after the emergency has ceased to operate. Moreover, while a proclamation of national emergency is in operation, the President can issue ordinances on the state subjects also if the Parliament is not in session. Further, the Parliament can confer powers and impose duties upon the center or its officers and authorities in respect of matters outside the Union list in order to carry out the laws made by it under its extended jurisdiction as a result of the proclamation of a national emergency. Effects on the Lok Sabha and State Assembly. While a proclamation of national emergency is in operation, the life of the Lok Sabha may be extended beyond its normal term, 5 years, by a law of parliament for 1 year at a time for any length of time. However, this extension cannot continue beyond a period of 6 months after the emergency has ceased to operate. Similarly, the parliament may extend the normal tenure of the state legislative assembly, 5 years, by 1 year each time for any length of time during a national emergency, subject to a maximum period of 6 months after the emergency has ceased to operate. Application of provisions relating to distribution of revenues. Article 354. Financial. While a proclamation of national emergency is in operation, the President can modify the constitutional distribution of revenues between the center and the states. This means that the President can either reduce or cancel the transfer of finances from center to the states. Such modification continues till the end of the financial year in which the emergency ceases to operate. Effects on fundamental rights. Articles 358 and 359 describe the effect of a national emergency on fundamental rights. Article 358 deals with the suspension of the fundamental rights guaranteed by Article 19, while the Article 359 deals with the suspension of other fundamental rights. However, the fundamental rights guaranteed by Articles 20 and 21 can never be suspended in any type of emergencies. These two provisions are explained below. Suspension of provisions of Article 19 during emergencies. Article 358. According to Article 358, when a proclamation of national emergency is made, the six fundamental rights under Article 19 are automatically suspended. No separate order for their suspension is required. While a proclamation of national emergency is in operation, the state is freed from the restrictions imposed by Article 19. In other words, the state can make any law or can take any executive action abridging or taking away the six fundamental rights guaranteed by Article 19. Any such law or executive action cannot be challenged on the ground that they are inconsistent with six fundamental rights guaranteed by Article 19. Any law made during emergency to the extent of inconsistency with Article 19 ceases to have effect when the national emergency ceases to operate. However, the legislative and executive actions taken during the emergency cannot be challenged even after the emergency ceases to operate. Restriction on Article 358. The 44th Amendment Act of 1978 restricted the scope of Article 358 in two ways. Firstly, the six fundamental rights under Article 19 can be suspended only when a national emergency is declared on the ground of war or external aggression and not on the ground of armed rebellion. Secondly, only those laws which are related with the emergency are protected from being challenged and not other laws. Also, the executive action taken only under such a law is protected. Suspension of the enforcement of the rights conferred by Part 3, Article 359. Article 359 authorizes the President to suspend the right to move any court for the enforcement of fundamental rights during a national emergency. This means that under Article 359, the fundamental rights as such are not suspended, but only the enforcement. The said rights are theoretically alive, but the right to seek remedy is suspended. The suspension of enforcement relates to only those fundamental rights that are specified in the presidential order. Further, the suspension could be for the period during the operation of emergency or for a shorter period as mentioned in the order, and the suspension order may extend to the whole or any part of the country. It should be laid before each House of Parliament for approval. While a presidential order is enforced, the state can make any law or can take any executive action abridging or taking away the specified fundamental rights. Any such law or executive action cannot be challenged on the ground that they are inconsistent with the specified fundamental rights. When the order ceases to operate, any law so made to the extent of inconsistency with the specified fundamental rights ceases to have effect. But no remedy lies for anything done during the operation of the order, even after the order ceases to operate. This means that the legislative and executive actions taken during the operation of the order cannot be challenged even after the order expires. Restriction on Article 359. The 44th Amendment Act of 1978 restricted the scope of Article 359 in two ways. Firstly, the President cannot suspend the right to move the court for the enforcement of fundamental rights guaranteed by Articles 20 to 21. In other words, the right to protection in respect of conviction for offences, Article 20, and the right to life and personal liberty, Article 21, remain enforceable even during emergency. Secondly, only those laws which are related with the emergency are protected from being challenged, and not other laws, and the executive action taken only under such a law is protected. Distinction between Articles 358 and 359. Distinction between Article 358 and Article 359. Article 359. Article 358. It is confined to the fundamental rights under Article 19 only. It automatically suspends the fundamental rights under Article 19 as soon as the emergency is declared. Article 359. It extends to all those fundamental rights whose enforcement is suspended by the presidential order. It does not automatically suspend any fundamental right via presidential order. It only empowers the president to suspend the enforcement of the specified fundamental rights. Article 358. It operates only in case of external emergency and not in the case of internal emergency. It suspends fundamental rights under Article 19 for the entire duration of emergency. Article 359. It operates in case of both external emergency as well as internal emergency. It suspends the enforcement of fundamental rights for a period specified by the President, which may either be the entire duration of emergency or a shorter period. Article 358. It extends to the entire country. It enables the state to make any law or to take any executive action inconsistent with the fundamental rights under Article 19. Article 359. It may extend to the entire country or a part of it. It does not empower the suspension of the enforcement of Articles 20 and 21. It enables the state to make any law or take any executive action inconsistent with those fundamental rights whose enforcement is suspended by the presidential order. State emergency or president rule, Article 356. Duty of the Union to protect states against external aggression and internal disturbance, Article 355. It shall be the duty of the Union to protect every state against external aggression and internal disturbance, and to ensure that the government of every state is carried on in accordance with the provisions of this Constitution. It is this duty in the performance of which the center takes over the government of a state under Article 356 in case of failure of a constitutional machinery in state. Provisions in case of failure of constitutional machinery in states. Article 356. The President's rule can be proclaimed under 356 on two grounds, one mentioned in Article 356 itself and another in Article 365, such as Article 356 empowers the President to issue a proclamation if he is satisfied that a situation has arisen in which the government of a state cannot be carried on in accordance with the provisions of the Constitution. Notably, the President can act either on a report of the Governor of the state or otherwise too, even without the Governor's report. It is known as state emergency or constitutional emergency. Article 365 says that whenever a state fails to comply with or to give effect to any direction from the center, it will be lawful for the President to hold that a situation has arisen in which the government of the state cannot be carried on in accordance with the provisions of the Constitution. Parliamentary approval and duration of the President's rule. A proclamation imposing President's rule must be approved by both the Houses of Parliament within 2 months from the date of its issue. However, if the proclamation of President's rule is issued at a time when the Lok Sabha has been dissolved or the dissolution of the Lok Sabha takes place during the period of 2 months without approving the proclamation, then the proclamation survives until 30 days from the first sitting of the Lok Sabha after its reconstitution, provided the Rajya Sabha approves it in the meantime. If approved by both the Houses of Parliament, the President's rule continues for 6 months. It can be extended for a maximum period of 3 years with the approval of the Parliament every 6 months. However, if the dissolution of the Lok Sabha takes place during the period of 6 months without approving the further continuation of the President's rule, then the proclamation survives until 30 days from the first sitting of the Lok Sabha after its reconstitution, provided the Rajya Sabha has in the meantime approved its continuance. Every resolution approving the proclamation of President's rule or its continuation can be passed by either House of Parliament only by a simple majority. Restriction on the power of Parliament to extend the duration. The 44th Amendment Act of 1978 introduced a new provision to put restraint on the power of Parliament to extend a proclamation of President's rule beyond 1 year. Thus, it provided that beyond 1 year, the President's rule can be extended by 6 months at a time only when the following two conditions are fulfilled. 1. A proclamation of national emergency should be in operation in the whole India or in the whole or any part of the state. And 2. The Election Commission must certify that the general elections to the Legislative Assembly of the concerned state cannot be held on account of difficulties. Revocation of President's role. A proclamation of President's role may be revoked by the President at any time by a subsequent proclamation. Such a proclamation does not require the parliamentary approval. Exercise of legislative powers under proclamation issued under Article 356. Article 357. The President acquires the following extraordinary powers when the President's rule is imposed in a state. He can take up the functions of the state government and powers vested in the governor or any other executive authority in the state. He can declare that the powers of the state legislature are to be exercised by the parliament. He can take all other necessary steps, including the suspension of the constitutional provisions relating to any body or authority in the state. Therefore, when the President's rule is imposed in a state, the President dismisses the State Council of Ministers headed by the Chief Minister. The state governor, on behalf of the president, carries on the state administration with the help of the chief secretary of the state or the advisors appointed by the president. This is the reason why a proclamation under Article 356 is popularly known as the imposition of president's rule in a state. Further, the president either suspends or dissolves the state legislative assembly. The parliament passes the state legislative bills and the state budget. When the state legislature is thus suspended or dissolved, the parliament can delegate the power to make laws for the state to the president or to any other authority specified by him in this regard. The parliament, or in case of delegation, the president or any other specified authority can make laws conferring powers and imposing duties on the center or its officers and authorities. The President can authorize, when the Lok Sabha is not in session, expenditure from the state consolidated fund pending its sanction by the Parliament, and the President can promulgate, when the Parliament is not in session, ordinances for the governance of the state. A law made by the Parliament or President or any other specified authority continues to be operative even after the President's rule. This means that the period for which such a law remains in force is not coterminous with the duration of the proclamation, but it can be repealed or altered or reenacted by the state legislature. Exception of powers of president under Article 357. The president cannot assume to himself the powers vested in the concerned state high court or suspend the provisions of the constitution related to it. In other words, the constitutional position, status, powers, and functions of the concerned state high court remain same even during the president's rule. Supreme Court on President's Rule. In Bommai case 1994, the following propositions have been laid down by the Supreme Court on imposition of President's rule in a state under Article 356. The presidential proclamation imposing president rule is subject to judicial review. The satisfaction of the president must be based on relevant material. The action of the president can be struck down by the court if it is based on irrelevant or extraneous grounds or if it was found to be malefic or perverse. Burden lies on the on the center to prove that the relevant material exists to justify the imposition of president's rule. The court cannot go into the correctness of the material or its adequacy, but it can see whether it is relevant to the action. If the court holds the presidential proclamation to be unconstitutional invalid, it has power to restore the dismissed state government and revive the state legislative assembly if it was suspended or dissolved. The state legislative assembly should be dissolved only after the parliament has approved the presidential proclamation. Until such approval is given, the president can only suspend the assembly. In case the parliament fails to approve the proclamation, the assembly would get reactivated. Secularism is one of the basic features of the constitution. Hence, a state government pursuing anti-secular politics is liable to action under Article 356. The question of the state government losing the confidence of the legislative assembly should be decided on the floor of the house, and until that is done, the ministry should not be unseated. Where a new political party assumes power at the center, it will not have the authority to dismiss ministries formed by other parties in the states. The power under Article 356 is an exceptional power and should be used only occasionally to meet the requirements of special situations. Conditions of proper imposition of president's rule, where after general elections to the assembly, no party secures a majority, that is hung assembly, where the party having a majority in the assembly declines to form a ministry and the governor cannot find a coalition ministry commanding a majority in the assembly, where a majority resigns after its defeat in the assembly and no other party is willing or able to form a ministry commanding a majority in the assembly, where a constitutional direction of the central government is disregarded by the state government. Internal subversion, physical breakdown, conditions of improper imposition of the president's rule. where a ministry resigns or is dismissed on losing majority support in the assembly, and the governor recommends imposition of president's rule without probing the possibility of forming an alternative ministry, where the governor makes his own assessment of the support of a ministry in the assembly and recommends imposition of president's rule without allowing the ministry to prove its majority on the floor of the assembly, where the ruling party enjoying the majority support in the assembly has suffered a massive defeat in the general elections to the Lok Sabha, such as 1977 and 1980. Internal disturbances, not amounting to internal subversion or physical breakdown, maladministration in the state, or allegations of corruption against the ministry or stringent financial exigencies of the state, where the state government is not given prior warning to rectify itself except in case of extreme urgency leading to disastrous consequences, where the power is used to sort out intra-party problems of the ruling party or for a purpose extraneous or irrelevant to the one for which it has been conferred by the Constitution. Emergency and President's Rule. National Emergency. Article 352. It can be proclaimed only when the security of India or a part of it is threatened by war, external aggression, or in armed rebellion. President's Rule. Article 356. It can be proclaimed when the government of a state cannot be carried on it in accordance with the provisions of the Constitution. National Emergency, Article 352. During its operation, the state executive and legislature continue to function and exercise the powers assigned to them under the Constitution. Its effect is that center gets concurrent powers of administration and legislation in the state. President's Rule Article 356. During its operation, the state executive is dismissed and the state legislature is either suspended or dissolved. The president administers the state through the governor and the parliament makes laws for the state. In brief, the executive and legislative powers of the state are assumed by the center. So that's the difference between the national emergency and the president's rule. Under National Emergency Article 352, under this the Parliament can make laws on the subjects enumerated in the state list only by itself, that is, it cannot delegate the same or to any other body or authority. Under the President's Rule Article 356, under this the Parliament can delegate the power to make laws for the state to the President or to any other authority specified by him. So far, the practice has been for the President to make laws for the state in consultation with the members of Parliament from that state. Such laws are known as President's Acts. National Emergency Article 352. There is no maximum period prescribed for its operation. It can be continued indefinitely with the approval of Parliament for every 6 months. Under this, the relationship of the center with all the states undergoes a modification. President's Rule. Article 356. There is a maximum period prescribed for its operation, that is 3 years. Thereafter, it must come to end and normal constitutional machinery must be restored in the state. Under this, the relationship of only state under the emergency with the center undergoes a modification. National Emergency, Article 352. Every resolution of Parliament approving its proclamation or its continuance must be passed by a special majority. It affects fundamental rights of the citizens. Lok Sabha can pass a resolution for its revocation. President's Rule Article 356. Every resolution of Parliament approving its proclamation or its continuance can be passed only by a simple majority. It has no effect on fundamental rights of the citizens. There is no such provision. It can be revoked by the President only on his own. Financial Emergency Article 360. Grounds of Declaration. Article 360 empowers the President to proclaim a financial emergency if he is satisfied that a situation has arisen due to the which the financial stability or credit of India or any part of its territory is threatened. 44th Amendment Act of 1978, implying the satisfaction of the President is not beyond judicial review. Parliamentary approval and duration of financial emergency. A proclamation declaring financial emergency must be approved by both the Houses of Parliament within 2 months from the date of its issue. However, if the proclamation of financial emergency is issued at a time when the Lok Sabha has been dissolved or the dissolution of the Lok Sabha takes place during the period of 2 months without approving the proclamation, then the proclamation survives until 30 days from the first sitting of the Lok Sabha after its reconstitution, provided the Rajya Sabha has in the meantime approved it. Once approved by both the Houses of Parliament, the financial emergency continues indefinite period till it is revoked. This implies two things. There is no maximum period prescribed for its operation, and repeated parliamentary approval is not required for its continuation. A resolution approving the proclamation of financial emergency can be passed by either House of Parliament only by a simple majority. A proclamation of financial emergency may be revoked by the President at any time by a subsequent proclamation without the parliamentary approval. Effects of financial emergency. The executive authority of the center extends to directing any state to observe such canons of financial propriety as are specified by it, and to directions as the president may deem necessary and adequate for the purpose. Any such direction may include a provision requiring the reduction of salaries and allowances of all or any class of persons serving in the state, and the reservation of all money bills or other financial bills for the consideration of the President after they are passed by the legislature of the state. The President may issue directions for the reduction of salaries and allowances of all or any class of persons serving the Union, and the judges of the Supreme Court and the High Court. Thus, during the operation of financial emergency, the center acquires full control over the states in financial matters. 42nd Amendment Act of 1976 facilitated the proclamation of national emergency in a part of territory of India or enabled the president to limit the operation of national emergency to a specific part of India, extended the one-time duration of the president's rule in a state from 6 months to 1 year, empowered the center to deploy its armed forces in any state to deal with a grave situation of law and order. The executive and legislative powers of center extends not only to a state where the emergency is in operation but also to any other state. 44th Amendment Act 1978. It was made mainly to nullify some of the other distortions introduced by the 42nd Amendment Act 1976, such as replace the term internal disturbance by armed rebellion in respect of national emergency, made the president to declare a national emergency only on the written recommendation of the cabinet, made certain procedural safeguards with respect to national emergency and president's rule, provided that the fundamental rights guaranteed by Articles 20 and 21 cannot be suspended during a national emergency, added the provision for periodical parliamentary approval for every 6 months. The 38th Amendment Act of 1975 made the declaration of a national emergency immune from the judicial review, but it was subsequently deleted by the 44th Amendment Act of 1978. Amendment of the Constitution, Article 368. Nature of the Indian Constitution. The Indian Constitution is neither flexible nor rigid, but a synthesis of both. The procedure is not so flexible as to allow the ruling parties to change it according to their whims, nor is it um, too rigid as to be incapable of adapting itself to the changing needs. Article 368 in Part 20 of the Constitution deals with the powers of Parliament to amend the Constitution and its procedure. It states that the Parliament may, in exercise of its constituent power, amend by way of addition, variation, or repeal any provision of the Constitution in accordance with the procedure laid down for purpose. It states that the Parliament may, in exercise of its constituent power, amend by way of addition, variation, or repeal any provision of the Constitution in accordance with the procedure laid down for the purpose. However, the Parliament cannot amend those provisions which form the basic structure of the Constitution. This was ruled by the Supreme Court in the Kesavananda Bharati case 1973. Article 368. Power of the Parliament to amend the Constitution and procedure thereof. Therefore, procedure of amendment. An amendment of the Constitution can be initiated only by the introduction of a bill for the purpose in either House of Parliament. The bill for this purpose cannot be introduced in the state legislatures. The bill can be introduced either by a minister or by a private member. It does not require prior permission of the president. The bill must be passed in each house by a special majority. Each house must pass the bill separately. In case of a disagreement between the two houses, there is no provision for holding a joint sitting of the two houses for the purpose of deliberation and passage of the bill. If the bill seeks to amend the federal provisions of the Constitution, it must also be ratified by the legislatures of half of the states by a simple majority. After duly passed by both the Houses of Parliament and ratified by the state legislatures, where necessary, the bill is presented to the President for assent. The President must give his assent to the bill. He can neither withhold his assent to the bill nor return the bill for reconsideration of the Parliament. After the President's assent, the bill becomes an act, that is, a constitutional amendment act, and the Constitution stands amended in accordance with the terms of the act. Types of amendments. The Constitution can be amended in the following three ways: amendment by simple majority of the Parliament, by special majority of the Parliament, and by special majority of the Parliament and ratification of half of the state legislatures. Article 368 provides for two types of amendments, that is, by a special majority and by a special majority of Parliament and the ratification of half of the states by a simple majority. Types of amendments. By simple majority, majority of the members of each house present and voting, not under Article 368. By special majority, majority of the total members and majority of two-third members present and voting, Article 368. By special majority and ratification of half of the states, Article 368. By simple majority, that is, a majority of the members of each house present and voting. These amendments are not deemed to be amendment of the Constitution for the purposes of Article 368. A number of provisions in the Constitution can be amended by a simple majority of the two houses of the Parliament outside the scope of Article 368. These provisions include the following: admission or establishment of new states, formation of new states and alteration of areas, boundaries, or names existing states, abolition or creation of legislative councils in states, second schedule, emoluments, allowances, privileges, and so on of the president, the governors, the speakers, judges, etc., quorum in parliament, salaries and allowances of the members of parliament, rules of procedure in parliament, privileges of the parliament, its members and its committees, use of English language in Parliament, number of puisne judges in the Supreme Court, conferment of more jurisdiction on the Supreme Court, use of official language, citizenship acquisition and termination, elections to Parliament and state legislatures, delimitation of constituencies, union territories, fifth schedule, administration of scheduled areas and scheduled tribes, sixth schedule, administration of tribal areas, and so on. By a special majority, fundamental rights, directive principles of state policy, all other provisions which are not covered by the first and third categories. By special majority and ratification of half of the states related to the where federal structure of the polity can be amended by a special majority of the parliament and also by the consent of half of the state legislatures by a simple majority. There is no time limit within which the states should give their consent to the bill. The following provisions can be amended in this way: election of the President and its manner, extent of executive power of the Union and the states, Supreme Court and High Courts, distribution of legislative powers between the Union and the states, any of the lists in the seventh schedule, representation of states in Parliament, power of the Parliament to amend the Constitution and its procedure, Article 368 itself. Criticism of the amendments procedure. No provision for a special body. The constituent power is vested in the Parliament. Parliament can neither approve or disapprove such a resolution or may not take any action on it. Major part of the Constitution can be amended by the Parliament alone either by a special majority or by a simple majority. Only in few cases the consent of the state legislatures is required, and that too only half of them, while in USA it is three-fourths of the states. Is the Parliament has unrestricted power to amend the Constitution under Article 368. 24th Amendment Act 1971. The Parliament reacted to the Supreme Court's judgment in the Golaknath case 1967 by enacting the 24th Amendment Act 1971. This act amended Articles 13 and 368. It declared that Parliament has the power to abridge or take away any of the fundamental rights under Article 368, and such an act will not be a law under the meaning of Article 13. Kesavananda Bharati case 1973. However, in the Kesavananda Bharati case 1973, The Supreme Court overruled its judgment in the Golaknath case 1967. It upheld the validity of 24th Amendment Act 1971 and stated that Parliament is empowered to abridge or take away any of the fundamental rights. At the same time, it laid down a new doctrine of the basic structure or basic features of the Constitution. It ruled that the constituent power of Parliament under Article 368 does not enable it to alter the basic structure of the Constitution. This means that the Parliament cannot abridge or take away a fundamental right that forms a part of the basic structure of the Constitution. Indira Nehru Gandhi case 1975. The doctrine of basic structure of the Constitution was reaffirmed and applied by the Supreme Court in the Indira Nehru Gandhi case 1975. In this case, the Supreme Court invalidated provision of the 39th Amendment Act 1975, which kept the election disputes involving the Prime Minister and the Speaker of the Lok Sabha outside the jurisdiction of all courts. The court said that this provision was beyond the amending power of Parliament as it affected the basic structure of the Constitution. Again, the Parliament reacted to this judicially innovated doctrine of basic structure by enacting the 42nd Amendment Act 1976. The 42nd Amendment Act 1976, this act amended Article 368 and declared that there is no limitation on the constituent power of Parliament and no amendment can be questioned in any court on any ground, including that of the contravention of any of the fundamental rights. Minerva Mills case 1980. However, Supreme Court in the Minerva Mills case 1980 invalidated this provision as it excluded judicial review, which is a basic feature of the Constitution. Parliament cannot, under the exercise of that limited power, enlarge that very power into an absolute power. Indeed, a limited amending power is one of the basic features of the Constitution. In other words, Parliament cannot, under Article 368, expand its amending power. Vaman Rao case 1981. Again, in the Vaman Rao case 1981, the Supreme Court adhered to the doctrine of the basic structure and further clarified that it would apply to constitutional amendments enacted after April 24, 1973. Elements of basic structure. The present position is that the Parliament under Article 368 can amend any part of the Constitution, including the fundamental rights, but without affecting the basic structure of the Constitution. However, the Supreme Court is yet to define or clarify as to what constitutes the basic structure of the Constitution. From the various judgments, the following have emerged as the basic features of the Constitution or elements, components, ingredients of the basic structure of the Constitution. 1. Supremacy of the Constitution, sovereign, democratic, and republic nature of the Indian polity, secular character of the Constitution, separation of powers between the legislature, the executive, and the judiciary, federal character of the Constitution, unity and integrity of the nation, welfare state, socio-economic justice, judicial review, freedom and dignity of the individual, parliamentary system, rule of law, harmony and balance between fundamental rights and directive principle of equality, free and fair elections, independence of judiciary, limited power of parliament to amend the constitution, effective access to justice, principles or essence underlying fundamental rights, powers of the Supreme Court under Article 32, 136, 144, and 1426, powers of the High Courts under Articles 226 and 227.